and it worked out. And I came up as an undergraduate about 15 years ago and studied law, and I was lucky enough to be able to stay and do graduate studies and eventually a PhD, and went from there into teaching. So I'd never expected when I came here that I'd still be here now, but that's the way it's worked out. And it's a bit of a surprise to me because at the time I wasn't sure I really wanted to go to Oxford. I nearly turned it down, actually. I thought it'd be way more exciting to go to London. Thought I might have a better time in London. But I decided not to do that in the end. I was sort of talked out of it. And, you know, for me, that turned out to be a good decision, at least I mean, who knows what would have happened in the alternative universe where I made a different decision. But certainly I've enjoyed being here, and I suppose that's shown by the fact that I'm still here all these years on. So anyway, that's enough about me, I think. I'm going to turn to the topic, prisoners and the right to vote. And so I'm going to be talking today about some of the law and politics surrounding whether prisoners should be able to vote in elections, and in particular in elections to Parliament. But what we thought we would do before I talk through some of the issues is ask you what your initial reaction is to this issue. So we've got some questions on the Slido. And well, they're on the slide, but I think you can answer them using Slido. And the first one is this: what are your initial thoughts on the question? Should prisoners have the right to vote? Should prisoners be able to vote in elections? So what we'd like you to do is to give one of three answers. I realise that we're sort of forcing you just to select one of three options, and of course in the discussion later on we can discuss some of this, but for now we want you just to pick one of these options: yes, no, or it depends. Oh, interesting. Okay, we've got some results coming through.
Luke, sorry to interrupt. I'm just going to remind our guests, because some have come in just in the last few moments, that if there it is, Trinity Talks 9. Go to slido.com and enter that event code. Thank you. Sorry, Arshad.
Oh, thanks, Richard. Yeah, that's the way to participate in this poll. Follow the instructions on the slide. So I think it's fairly split. Majority for it depends. Substantial number of people saying yes, and a quite significant number of people saying no. Okay, what we're going to ask you to do now is to try and sum up in just 2 or 3 words what some of the thoughts are that make you think there are convincing arguments for prisoners being able to vote. In other words, if you could sum up in just a word or a couple of words why prisoners should be able to vote, and if you could put that into the Slido, then I'm hoping that we'll get a word cloud which will show some of the factors that you think are relevant. What are the factors, the reasons that you think might be relevant for people, for prisoners being able to vote? Oh, some really interesting things coming through already. Freedom, equality, democracy, human rights, lots of votes for human rights, true political equality, reintegration, a degree of crime, seriousness of crime. They could be reformed, effect on their life. Everyone should have a say. Wow, lots and lots of really interesting things there. I see them coming up in larger font now: severity of crime, democracy. Yeah, I mean, all of those things are of course very, very relevant to this issue, and show just how interesting and complicated it is. We're now going to ask you the converse question. So could you sum up in 2 or 3 words what might be some of the reservations against prisoners being able to vote? some of the factors that point the other way, factors for not giving them the ability to vote. I'll just give you a moment to type some things in. Okay, good. Again, lots of interesting things coming through. Punishment, that's a very interesting thought, that is part of the punishment for the crime committed, that you're not able to vote. Broken the law, lawbreakers, some have committed murder, so a worry there about the seriousness of the crime. Lots of votes, I think, for law breaking, things around law breaking. References to the aims of punishment, so deterrence, retribution, loss of privileges, effect on society. Yeah, so again, lots of very interesting thoughts, and I hope we'll come back to some of these points and unpack some of them a bit further in today's session. So I think if we could go back to the slides. Great, thank you, Richard. Could you move us on to the structure? Yeah, thank you. So I'm just going to start off with an overview of the talk that I'm going to give. I suppose just before I do that, there's one thing to say about the right to vote, which is that, of course, it is an essential attribute of a modern democracy, that citizens have the right to vote in governmental elections. But there is a question that has to be asked about who is the electorate, who gets to participate in elections. And of course, all states place some restrictions on who can vote. For example, restrictions on the age at which people might be able to vote. And I think one of the very interesting debates over the last decade or so is whether that should be lowered, as it has been in some countries, to 16. So every state places some restrictions, and therefore there's a question about what restrictions should be imposed, and that includes whether restrictions should be imposed on prisoners. And what I'm going to do today is focus on the position in the United Kingdom. If there's time, I might say a little bit about the different position across different parts of the UK. For example, there are special rules that apply to elections to the Scottish Parliament, but I'm going to focus mainly on the rules that apply to elections to the UK Parliament. And I'm first going to introduce the general rule that prevents most prisoners from voting in parliamentary elections. I'm then going to talk about how that rule was challenged in the leading case of Hearst and United Kingdom. You may have heard of this case. It's been widely discussed in the media, and actually quite often it's been misunderstood. What the courts have actually said has not always been properly reported. That's in many ways not surprising. The details are complicated, and as a result, I think sometimes the courts have been unfairly criticised. And I don't mean to say that the courts have necessarily made the right decision. Perhaps they made the wrong decision, and that's something I want us to think about. But any useful discussion, any fruitful discussion, has to be based on a correct understanding of what the courts really decided, right? If we're going to criticise them, we should criticise them for what they decided, not for some fictional account of what they decided. And so one thing I'm quite keen to do is to go through what the courts have actually said, and then we can think about whether there are grounds for criticism. So having done that, the third thing I'm going to do is look at how the UK government has responded to that very controversial decision in Hearst. And then finally, there will be some questions, and I think we'll take a poll again at the end of the talk to see whether any of you have changed your mind in one direction or the other. So let me begin then with the general legal ban on voting by prisoners. If we could have the next slide, please. Thanks. So in this country, a person who is in prison and who has been convicted of a criminal offence is legally incapable of voting in parliamentary elections or in local elections in England. And the rule is to be found in Section 3 of the Representation of the People Act 1983. And I've given you the text of this law on the slide. So the Representation of the People Act is an act of Parliament. Some of you might know that an act of Parliament is a law passed by Parliament at Westminster, usually through being approved by both Houses of Parliament, so the House of Commons and the House of Lords. And it is a basic feature of the UK's political system that Parliament can make or unmake any law whatsoever. That is known as parliamentary sovereignty. And we've all heard a lot about that in the context of the Brexit discussions. It was true that when we were a member of the European Union, there was quite a significant restriction on parliamentary sovereignty. But anyway, let's not worry about that for the moment. The basic rule is that Parliament can make or unmake any law whatsoever. And this is one of the laws that Parliament has made. Some things to notice about the wording of the law. Note that it says these people are legally incapable of voting. So it's not just that in practice prisoners can't go out and vote because they're in prison. It's that it's legally impossible for them to vote. Right? They don't have the ability in law to actually vote. Note also that it applies to convicted prisoners, so people who've been found guilty of a criminal offence, and those who are detained in prison or are unlawfully at large. So what that means is it doesn't apply to people who are being detained in prison before being convicted. So people who have been arrested but haven't been released on bail before their trial, right? It doesn't apply to them. Nor does it apply to people who have been released into the community. For example, people who are being detained at home with an electronic tag, right? Because those people are not being detained in a penal institution. So you have to be a bit careful when thinking about the scope of this rule, and I'll come back to that point later. The key thing is it does apply generally to anyone in prison convicted of an offence. Great. Can we have the next slide, please? Okay, so I'm going to move on to part 2 of the talk, which is about the Hearst litigation. In 2001, 3 prisoners, including Mr. John Hurst, challenged that general ban on prisoner voting. They challenged the law which we've just looked at. Mr. Hurst had been sentenced to life imprisonment for manslaughter. And since he was someone who had been convicted of a criminal offence and who was being detained in prison, that law applied to him. In other words, he was unable in law to vote. And so he brought a court case in London, arguing that the rule, the legal ban, was incompatible with human rights law, and in particular with his right to vote. And he argued that that right was conferred by the European Convention on Human Rights. So I want to say a little bit about the European Convention, what it is and how it works. So briefly, the European Convention on Human Rights, as some of you may know, is an international treaty drafted in 1950, so shortly after World War II, by the Council of Europe. It was a response both to the horrors of World War II, including the atrocities committed in Nazi Germany, and also to the emergence of Stalinism in Eastern and Central Europe. And it was part of an attempt by the Allied powers, or by some of them, to prevent the serious human rights violations that occurred in the 1930s and 1940s. Now, I said it was drafted by the Council of Europe, and it's really important not to confuse that body, the Council of Europe, with a separate body, the European Union. So the European Union, as you might know, is made up of 27 states, and it has a particular set of institutions, including the European Court of Justice. But the Council of Europe is a separate organization. It has 47 members, including at the moment Russia. Russia is currently a member of the Council of Europe, although it will be expelled later this year as a result of the war in Ukraine. Now, Russia, of course, has never been a member of the EU, but it has, up until this year, been a member of the Council of Europe. And so I suppose the point I'm trying to make is, do not confuse the European Union, which the UK has, of course, left, with the Council of Europe, which we are very much still a member of. And as an international treaty, the European Convention is an agreement between states. So the 47 states that are members of the Council have all signed up to the Convention. They've all agreed to respect the rights conferred by the Convention. And one thing that's pretty unusual about this particular treaty is that there is a court that can decide whether members of the Council have respected the rights conferred by the Convention. This is the European Court of Human Rights, a body you might have heard of. And as I say, it's separate from the European Court of Justice. So the European Court of Human Rights is based in Strasbourg in France, and individuals, you, me, we can go to that court and claim that a particular state, the UK, France, Italy, or any other state, has violated one of the rights protected by the Convention. And it is the job of that court to interpret the Convention and to apply it to resolve disputes between individuals and states. So, in this Hursts case, one of the complications is that there were two separate systems of law in play. There was the law of the United Kingdom, which includes the Representation of the People Act, the law imposing the ban on the right to vote. That's what you might call UK national law. But secondly, there was also the law of the European Convention, which is part of international law. Now, I said earlier that Mr. Hearst brought his case in London, which is true. He didn't bring his case to start with in France. How was that possible? How could Mr. Hearst bring a claim in the London courts as opposed to in Strasbourg? Well, the answer has to do with the Human Rights Act, which is something else you might have heard of. It was enacted by Tony Blair's Labour government in 1998. And basically, Blair's government thought it was problematic that if British people wanted to enforce their human rights, they had to go to France and start proceedings in Strasbourg. They thought it would be better if British people could enforce the Convention rights in British courts. And that's basically what the Human Rights Act does, right? It allows us to rely upon the Convention in British courts. And in particular, it means that British courts can make a declaration if they think a particular law of this country is incompatible with the Convention. If they do that, it doesn't affect the validity of that law, right? So if the court says, oh, this particular law is incompatible with the Convention, the law's still valid, right? So judges don't have the power to strike down the law, but they can make that declaration. They can say to the government, they can say to Parliament that we think this particular law is incompatible with the convention which you signed up to, and it's then for the government and Parliament to decide how to respond, whether to respond. And we're seeing the Hursts case that actually the government, at least for a long time, decided not to respond. So let's go back to Mr. Hearst. As I said, his argument was that the rule saying that prisoners, convicted prisoners, are incapable of voting is incompatible with his convention rights. But what convention rights did he rely upon? Well, if we could have the next slide. Thanks. Oh, sorry, I should have given you this one earlier. This is the one on the Human Rights Act. We can skip over that. Next slide, I think. Yeah, good, great, thank you. He relies on Article 3 of Protocol 1, and as you can see, this says the high contracting parties, that just means the states, so France, Italy, the UK, undertake to hold free elections at reasonable intervals by secret ballot. And so this is what Mr. Hearst relied upon in his case. Now, you might have noticed that this article doesn't expressly confer any rights on individuals. And in that respect, it's quite different from other parts of the convention. And I've got some examples on the next slide. Thanks. So Article 2, for example, says no person shall be denied the right to education. So that's Article 2 of the First Protocol. Article 2 of the Convention says everyone's right to life shall be protected by law. So clearly those provisions of the Convention do give individuals rights against the state. But Article 3 of the First Protocol doesn't actually confer expressly any rights on individuals. It just says that the member states undertake to hold free elections. So if we could have the next slide, please. The court, however, concluded that Article 3 does confer rights on individuals, even though it doesn't say that expressly. And the court thought it was implicit in what is said in the Convention, that individuals have certain rights under this article, including the right to vote and the right to stand for election. And one thing that they looked at to reach that conclusion was the general wording of the Convention, and there were references elsewhere to the rights protected by Article 3. And the court says, well, if it says there are rights protected by Article 3, then Article 3 must confer rights, and therefore it must confer the right to vote and the right to stand for election. So that's an example of how the courts might interpret a particular law to work out what's implicit in it. And certainly one of the things you spend a lot of time doing as a lawyer is thinking about what might be implicitly stated, even though it's not stated expressly. Okay, if we could have the next slide. Good. So the question now is, given that individuals have a right to vote, according to the court, can restrictions be placed on that right? Or is it absolute? Is it a right that cannot be qualified? For example, the right to torture, which is another right, sorry, the right not to be tortured, which is another right conferred by the Convention, is said to be an absolute right. There are no circumstances in which your right against the state not to be tortured can be restricted. Well, the court said no, the right to vote isn't absolute. It's not like the right not to be tortured. It is rather a qualified right. And what that means is states can place restrictions on the right to vote. But in order for those restrictions to be justified, they have to meet 3 conditions. And I've given you the conditions on the slide. So first of all, the conditions must not impair the essence of the right. Right. So if you try to impose a law banning all elections and it tried to create a totalitarian system with a dictator, clearly that would impair the essence of the right to vote, and that just wouldn't be allowed under the convention. Secondly, even if it doesn't go against the essence of the right, the restriction must pursue a legitimate aim. There must be some reason why you're doing this, right? The government can't just decide for no reason at all that it wants to restrict the right to vote. There must be some legitimate aim. And thirdly, the means must not be disproportionate. In other words, you can't use a hammer to crack a nut, right? The government's allowed to restrict the right insofar as it's necessary in order to achieve a legitimate aim, but it can't go beyond that. It can't impose an excessive restriction. So I suppose the thing to do now is to think about how to apply that in the context of the right to vote. So let's go back to the case of Mr. Hearst. If we could have the next slide, please. So Mr. Hearst made two arguments to try and show that the restrictions imposed on the right to vote were unjustified. First of all, he said, well, there's no good reason to impose restrictions on the right to vote insofar as prisoners are concerned. Why not? Well, you might say that we should impose a restriction as a punishment, and that would be legitimate. But Mr. Hearst argued that the punishment was the loss of liberty, and that other rights and privileges should not be lost. His second argument was, well, okay, even if there are going to be some restrictions on prisoners' rights to vote, the current rules go too far. They're excessive. They go beyond what's needed and therefore are disproportionate. So those are the arguments. Let's have a look at how the court responded to those arguments. If we could have the next slide. Thanks. So before we get to the thing on the slide, actually, let me just say one thing to complete the story. I said earlier that he started his case in London. Well, he did. He made those arguments I've just outlined, and he lost. Right? The English courts held that there was no unjustified restriction on his right to vote under the convention, and so it dismissed Mr. Hearst's case in London. So Mr. Hearst wasn't very happy with that, and his lawyers probably weren't very happy either. So they decided to start a new case in the Strasbourg court, the European Court of Human Rights. And you can definitely do that, right? If you bring an action in the British courts under the Human Rights Act and you lose, you can then go to Strasbourg and you can make your case before the European Court of Human Rights. That is what Mr. Hearst did. And this time he won. The European Court of Human Rights held, by 12 votes to 5, that the legal ban in the Representation of the People Act on prisoners voting violated Mr. Hearst's right to vote, and therefore it breached the European Convention on Human Rights. I suppose the interesting question is why? Why did the court think that? So I'm going to just briefly go over what the court decided. Thanks. So the first thing to say is that the court's starting point was that prisoners in general continue to enjoy all of the rights and freedoms guaranteed by the convention. In other words, it's not the case that as soon as you are imprisoned, you become a sort of second-class citizen and you lose all your human rights. And one of the court's arguments is, you know, just because you're a prisoner, that doesn't mean that you don't have a right not to be tortured, for example. So the starting point is prisoners retain their rights. And it's then for the state, it's for the government to show that it's justified to impose restrictions on those rights. So starting point, he still had his right to vote. That right was interfered with by the rule we looked at earlier, and now it's for the state to justify that restriction. So what did the court say about that? Well, if we could have the next slide. They said there are two steps you've got to go through to work out whether it's justified. This is part 2 of what's there on the slide. And this reflects what we looked at earlier. Did the interference with the right to vote pursue a legitimate aim? Well, the court said yes to that question. They said restricting prisoners' capacity to vote does pursue legitimate aims. There are good reasons to do that. First of all, it might help to prevent crime, which is obviously a legitimate aim, and it also enhances respect for the law. The idea being that if you breach the law, you then lose some of your entitlements as a citizen, and that helps to foster respect for the law. So then they got to the final question, which is, well, given that there are good reasons for these restrictions, do the restrictions go only so far as is necessary to meet those objectives, or do they go too far? Are they disproportionate? And on that, the court held that the current rules are disproportionate. They go too far. Why? Well, I think we've got the answer on the next slide. This paragraph really gives you the essence of the court's thinking on this. And you can see in the first sentence, the court said, look, this law is a blunt instrument. It strips of their right to vote a significant category of persons, and it does so in a way which is indiscriminate. It imposes a blanket restriction on all convicted prisoners in prison, and it applies automatically. And then you get the sort of conclusion in which I've highlighted for you. Such a general, automatic and indiscriminate restriction on a vitally important right must be seen as being incompatible with the convention. And for that reason, the court concluded that UK law violated Article 3 of the European Convention on Human Rights. Just before leaving this and moving on to the final part of the talk, which will be a bit briefer, I just want to emphasize how important it is to look carefully at what the court is saying here, right? So the court did not say that under the European Convention, all prisoners must have the right to vote. Didn't even say that most of them should. What it said was the current ban, the current blanket ban, which applies generally and automatically and indiscriminately, is problematic. It's disproportionate. And so, you know, to elaborate a bit on what the court is saying there, the prison population is really varied, right? People are there for all sorts of reasons. Some of them have committed quite minor offences. Some of them have committed very serious offences. Some of them are repeat offenders. Some of them have very long sentences. Some of them have very short sentences. And yet our rule just applies across the board. And it was that aspect of it, the broad and general nature of the ban, that the court thought was problematic. So how did the government respond? Well, this brings me to part 3 of the talk, and the next slide. Well, it's fair to say, I think, that decision of the court has proved really controversial in this country. Successive governments have expressed hostility towards it, and many parts of the media have been very critical too. I've given you an example of the sort of reaction to the decision. In 2012, the then Prime Minister David Cameron said, "No one should be in any doubt. Prisoners are not getting the vote under this government." What I think is quite interesting, though, is whilst those sort of statements were being made, in the newsrooms and on the radio, behind the scenes, the government was exploring how to respond to the ruling. And in 2012, November 2012, so just a month after David Cameron made that statement, Chris Grayling, who was then the Justice Secretary, presented to Parliament a bill which set out 3 options. And I've given you on the slide a summary of those 3 options. So one option was just to retain the current ban. Another option was to impose a ban on voting for prisoners sentenced to more than 6 months in prison. And the third option was to impose a ban for prisoners sentenced to 4 years or more. And you'll see that those 2 options are quite different from what was criticised in Hearst, because under these proposals, we would be drawing a distinction between those with short sentences and those with much longer sentences. And a parliamentary committee was asked to look at this, and it recommended that we should draw the line at 12 months. So prisoners with a sentence of more than 12 months should be prevented from voting, but those serving sentences of less than a year should be allowed to vote in parliamentary elections. But nothing happened. The proposals were not taken forward. If we could have the next slide. There was further wrangling, and eventually the government made a commitment to the Council of Europe that it would do something. The UK was being criticised on the international stage. We were in breach of the convention. We remained in breach for over a decade, and eventually the government said, "Okay, we'll do something." But what it decided to do was pretty minor. It said it would do 2 things. First of all, just notify prisoners upon conviction that they would lose the right to vote. Right, so just going to tell them that is something that will happen to them. And then secondly, clarify the guidance to prisons to allow prisoners who have been released from prison for home detention to be able to vote. And so that does allow a limited number of convicted prisoners to vote, but it doesn't do anything about the general ban, right? The general ban for convicted prisoners who are in prison remains. And for that reason, since it's still the case even today that Section 3 of the Representation of the People Act is law, nothing's been introduced to change that. The general ban remains. Many lawyers have argued that the UK law is still in breach of the convention despite these minor changes, and that some of them would therefore argue our law needs to be changed. Of course, others think that we should keep the law as it is, that we shouldn't bring about any changes to the general ban. So that's probably enough from me. That's what I wanted to say in terms of giving you an overview of some of the issues. And really, we've only scratched the surface of some of the arguments that are relevant to this issue. But I think what we'd like to do as a next step, Richard, is to do another poll and see whether anything I've said has led you to change your minds, or whether you're still of the view that you were about 40 minutes ago. So I think we can go to the Slido and give you those same 3 options. Should prisoners have the right to vote? Yes, no, or it depends. Looks like a lot more votes for it depends, which I suppose reflects some of the discussion we've had today. But still some yeses and some no's. So I think a little bit of a change there, but maybe not an extremely substantial change. We're now going to going to ask you a question which is perhaps a bit unfair in the light of what I've said for the last 40 minutes, which is, if you had to choose between yes or no, what would you say? And I realise that this is a bit of an unfair question, but we're just interested in your responses. Can see the votes coming through. That's interesting. It's quite split, it seems. A majority for yes, but still 35% on no, which is quite significant. Richard, could I ask you about the next step?
Yeah, I'm fascinating responses there, weren't they? A question from me, I don't think it's an easy one to answer, Luke. Question from me might be, do you think that what we've just seen in the poll there, that latter one where we did unfairly kind of force in inverted commas a yes or no answer, do you think that was reflected in the national media at the time of the Hursts case?
So you mean the
yes, or do you think the national media?
No. I mean, I think interestingly, the coverage in the media generally was extremely negative. I think when you look at polls of the public, it's a bit more nuanced than the media coverage would suggest. But I don't think that the coverage in the media reflected what we've just seen, which was a sort of majority for giving prisoners the right to vote.
And who says that the national media reflects national opinion anyway? Sometimes it might just be a few. I remember, I'm not going to mention but I remember some of the headlines in one particular newspaper that everybody will have heard of that were pretty, pretty angry.
Yeah. And the thing that's so frustrating about lots of that coverage is as I said earlier, it wasn't looking very carefully at what the court actually said. It was sort of exaggerating the issue and saying, well, the European Court says that all prisoners should have the right to vote. And of course, that isn't what the court said at all.
Yeah.
Have we got time now for some questions?
Yeah, absolutely. So we'd warmly welcome any questions, and it's great to see you've already asked a couple. So that's super. There may be questions about prisoners and the right to vote, or the Hursts case, for instance, or there may be questions more broadly about, studying law at Oxford, super curricular resource in law, that sort of thing. So let's start with a really nice broad one. What resources are the best for those who want to look into law more?
Sorry, I didn't quite catch that. Is that what
resources, what sort of super curricular resources, perhaps, if any, that you particularly recommend for prospective law students?
Oh, that's a really good question. So there are quite a lot of introductory guides and books aimed at people who are thinking of studying law. And if you look on the Oxford Law Faculty website, for example, which is law.ox.ac.uk, and look at the section for new applicants, there is there a list of books, and perhaps if I've got time in a moment, I'll see if I can copy and paste it into the chat.
We haven't actually got any chat, Luke, but
what
we can do is if you send it to me, I'll send it out in the follow-up email.
Oh, let's do that. Okay, so
Brilliant.
I'll send a list to Richard that he can send round to you all. So
that's going to all registered, more widely than those who are here tonight as well.
Yeah, because there is a list of some really good resources, and I think rather than me trying to go through them and get you all to correctly write down the names of the authors and so on, it might just be best to do that. There are also some good blog posts, blogs you could follow. Perhaps we could send those around by email as well, Richard. Blogs on human rights law, blogs on constitutional law.
Brilliant. And there's another question about sort of specifically corporate or criminal law as well. So I guess they'll probably be covered on the law faculty resources you're referring to.
Yeah, I can't see that question.
Sorry, it's just because I'm putting them through. Do you have any book recommendations or chapters of books to look further into the subject of law in specific areas of corporate criminal law? Yeah. Okay, so we've got quite a lot of questions coming through. I'll kind of go broad to specific. So with that in mind, this is really broad. When studying law, what types of things do you learn about?
That's a good question. So the focus is going to be on the body of rules and the institutional structures that make up a particular legal system. So, you know, if you're studying law in this country, that's going to be looking mainly at UK law, and in particular at say, you know, a university in England, the law of England and Wales. Although there are opportunities to look at other legal systems too. So here, for example, we have options in comparative law, Roman law, international law, legal history, European Union law. So as I say, what that's going to involve is looking at the body of rules and also the structure of the institutions. So the role of Parliament, for example, the role of the courts. We also spend a lot of time looking at legal reasoning. So, you know, it's not the case that legal reasoning is just moral reasoning. There's some overlap, there are some similarities, but there's a whole range of special techniques, methods, modes of thinking that lawyers use in court and which judges use in their judgments. And so law students spend a lot of time learning what the particular techniques are. And once you've mastered those techniques, one of the really interesting things is to then draw upon general moral reasoning to evaluate the methods, the modes of argument that are used in the courts. So I suppose what I'm trying to say is it's partly subject matter, the rules of this system or this body of rules, the body of criminal law, body of corporate law, body of international law, but it's not just that. It's also methods of argument, modes of thinking, conceptual structures. That's
useful also to look at course outlines at different universities. I guess perhaps there may be.
That's a very practical point. Yeah, so you could look at the course outlines on the websites for different institutions. I should say in this country, most law courses have a lot of overlap. And the reason for that is that there are certain compulsory components that anyone has to study in order to get a qualifying law degree, a degree you can practice with. So if you look at those different course outlines, you'll see there's a lot of overlap. You have to do criminal law, property law, contract law, and there are some others you have to do too.
And that's essentially because it's partly about a profession, I guess, and professional qualifications, whereas, say, to take another subject randomly, history, English, if you look at different history degrees across different universities, they're going to vary more, aren't they? Exactly. But there's still plenty of optionality, isn't there? There's been a question, what do you find the most interesting area of law to study? I mean, I would refer, I guess, to your professional interests. You've been, you know, I pre-publicized, for example, your profile on the law faculty website, you know, where you've got your sort of publications. You're particularly interested in, just remind us of those interests.
Sure, yeah. So I generally focus on what's called private law. So we divide law into public law and private law. Public law is about the relationship of individuals to the state, and that includes some of what we've been looking at today. Private law is about the rights and obligations individuals owe to one another. So it includes property law, contract law. And most of what I teach is focused on that. Most of what I write about is focused on that, with a particular focus on property rights. I think it's particularly interesting to look at who gets rights to which things and how the legal system allocates rights over assets. But one of the things that has always interested me is the interaction of different bodies of law. And so, for example, I do have an interest in human rights law and how that relates to property.
Wow, so real, you can see why you're particularly passionate about this topic. I'm going to go a bit quick fire here with you, Luke, just to cover a couple of quick ones. Any, and people who've asked questions will recognize that I'm doing this in a themed way, so it's sort of hopefully coherent. Any tips for recommending for the for preparing for the LNAT?
Yes, practice. There are sort of there are practice papers you can do. and I think it's worth doing those to get a sort of sense of the thinking that's required for the LNAT. The other thing to say is that it doesn't require knowledge of law, so don't worry about trying to, acquire knowledge of law. It's not testing that. It's meant to be testing how you think, how you reason.
Are law and criminology linked?
Yes, very much so. Criminology, for those of you who don't know, is the study of the criminal justice system in all its aspects, including how it works in practice. And I mean, it is, if I can say one thing very quickly, it is true that as doing a law degree, you spend a lot of time looking at what the rules are and how the institutions work. But it's also really important to think about law in action and what's actually going on the ground. And criminology is doing that, but in the criminal context.
Brilliant. By the way, if you've asked the questions which relate to the theme under discussion, coming back to them in a minute, so don't think we're sort of ignoring you. You can probably work out I'm asking the admissions related questions now. Great question here, because it's on the basis that it's one that's frequently asked. Is law work experience considered a supercurricular activity and one thus to be sort of, really in the academic part of the statement about law, or is it limited to wider reading and podcasts, etc.?
It's a good question. I think it partly depends upon what you're doing on the work experience.
Right.
I think it probably counts as super curricular as long as you're doing some work that you can show is related to the course, and probably with any type of legal experience you can make that connection.
Brilliant, and a bit of reflection on it as well. But one that I've taken from that, this isn't a student question, but this is from me, but it's linked. Should you have done work experience for a law degree application?
No, you don't need.
I was definitely leading you to that response. I was hoping you were going to say no.
You definitely don't need to have done legal experience. Don't worry about doing it. What we are interested in why you want to study law, and one way to show your interest is to draw upon some work experience if you've done some. But it's not the only way. There are lots of other ways to show why you're interested in doing a law degree, and that might be on the basis of things you've read, cases you've heard about in the news, or other things too. So don't worry if you can't secure legal work experience.
Couple of questions. I think they're both wonderful, but relate to the theme, and then we'll conclude. Okay. The first one reminds me of that thing you do. Maybe I don't know whether I'm the only person who did this, but when you were little, when you thought about something disgusting, and you said, how much would you need to be paid to do that? Like, I don't know, licking a puddle or something. Would you lick that puddle for £20? And then you have a threshold, don't you? And you discover you would do it for £20, but you wouldn't do it for £19. There is an analogy. If there was to be a criteria or a limit on those who were able to vote as prisoners, what would your threshold look like? So I guess that's length of sentence.
Yeah, I think it's a good question. I think there's a lot to be said for what the Parliamentary Committee recommended, which is drawing the line at 12 months. That does seem to reflect the seriousness of the offence, in that minor offending does tend to attract a sentence of a few months, and more serious things over a year. And interestingly, in Scotland, and I said earlier things are different in Scotland, they have adopted that rule. In Scotland, when it comes to local elections and elections to the Scottish Parliament, people serving sentences of less than a year are able to vote in those elections. So I think
any threshold has to be arbitrary, doesn't it?
Yeah.
Really? And so hence my silly analogy with, a little person making a joke about licking a puddle or something,
To say, Richard, really briefly, that touches on a general issue in law, which we constantly have to draw lines, right? Why is the speed limit 30 miles an hour, not 28 or 35, right? You've got to draw a line somewhere, and you can't always perfectly justify why you're drawing it there.
Yeah. Oh, that makes me feel better about my silly licking puddles or something. Anyway, moving on from that, but this is a $64,000 question for you, Luke, to conclude. What do you think about this topic? I think you've given an indication there in the last answer, but would you be willing to share what your thoughts are on the so should prisoners be able to vote? I think you just have implicitly.
Yeah, no, I think there are strong arguments for reform. I think the court's onto something when it says the current ban is a blunt instrument that isn't sufficiently nuanced. and it would be better to have a rule which distinguished between serious offences and minor offences. And I mean, there are different ways of doing that, but a sort of simple way of doing it is to focus on length of sentence. It's not perfect. Maybe you're thinking, well, that it seems a bit unfair if someone just falls on one side of the line. But as I was sort of suggesting a moment ago, often with legal rules, there's no perfect way of drawing the line. And I think it would be a slightly more nuanced response than the current rule.
Brilliant, and thank you for your candor as well in sharing your opinion there and all your advice as well in terms of law applications. Luke, I can't thank you enough. It's been really interesting tonight. It's a really kind of political, human rights based issue, isn't it? And one I hopefully made clear in the pre-publicity that I thought was hopefully of reference to of interest to people beyond prospective law students, because sort of humanities and social sciences you could argue as well. Thank you so much on behalf of our guests, and also to you guests. Thank you so much for joining us tonight. You'll see the follow-up email and some resources there, but also the link to the YouTube recording once it's uploaded, and also the PDF of tonight's slides. Thanks all. Really good evening. Thank you for joining us. Bye.
Bye all.